Well, thank you all for waiting. Normally, I'm 15 minutes early because I was raised that if you're not early, you're late already. And so I'm looking at my watch thinking this is not good. But I did just come in from Albany, so why don't I start there with what's going on in Albany. The press is not covering anything other than rent control, but for us, where we are is on the eve of actually having a bill numbered in both houses that is the same as for full repeal. I can't tell you how the votes are going to go. I don't know how the negotiations are going to go. All I can tell you is that it's the closest we've actually been to having some for real legislation on full repeal since this whole nightmare began. My understanding is that's making the governor unhappy. He may need therapy. It's also making, though, some of our legislators unhappy. So I think that's maybe where I want to start with you from an activism standpoint is this. We do not have a united Republican conference. Let me tell you, from 2 solid days on the ground, going back and forth, if you know the setup in the building, between the Senate chambers and the Assembly chambers, and then up and down every floor in the Legislative Office building. And if you've been following on our Facebook page and you've been calling in as we've put out the urgent action alerts with the names of various members of the Senate Republican Conference and their telephone numbers, at one point yesterday, what I was told was we only had 20 out of 32 of the Senate Republicans on board for full repeal.
Where are they from?
Think about that for a minute. 1/3 of the conference doesn't see the Second Amendment as sufficiently important to spend political capital in Albany. What they have been trying to do is pass what's called a partial. Their version of a partial is this. The SAFE Act is a 39-page single-spaced bill that came out of the Senate in January of 2013. I've lived with it on a full-time basis since the minute it passed the Senate, even before it passed the Assembly. So when you tell me you got a 10-page double-spaced partial repeal that covers all of 4 topics, the question we're getting is, will that appease your membership? No. I'm being very ladylike. I'm doing exactly what I just did there. Like, you don't want to know what I'm thinking when you ask me that question. You just really don't. I can't say enough Hail Marys or make acts of contrition to make up for what goes through my mind when I get questions from sitting members of the New York State Senate and Assembly whether our members can be placated with a partial bill. What's it going to take to get our members to be quiet? What's it going to take to get them to stop calling our offices? What's it going to take to stop a primary candidate? Well, how about you stand for Republican and conservative values? We can start with that. And we can start with the Second Amendment as a fundamental right. And we can start with, well, wait a minute, you've come to our scope meetings, you've asked for our endorsements already, you've asked for high ratings during our election cycles. In fact, you've asked for money. Apparently, we don't give enough money. Part of what I'm understanding is that the New York City PACs give the candidates more money than we do. Last time I checked, no matter where your money's coming from, you still represent the people in your district, or did I miss something? Like, was there some revision to the New York State Constitution I missed y'all are aware of? I try to keep up with it. Our Constitution in this state gets amended as often as a blog, a periodical. It's hardly treated as cast in stone. But the last time I checked, when you represent somebody from your district, you have to represent what they're asking you to do. So we've made a mighty noise. Really, our outreach campaign started on Sunday night when we first caught wind that Assemblyman Pete Lopez had introduced Bill Assembly 8215 that called for a full repeal tied to New York City rent control. Now, the funny thing about all of this is, of course, we started out with all kinds of problems with New York City 3 years ago. We're now tied, once again, to New York City. The New York City contingency is saying they don't really care about the SAFE Act, and my response to that is, well, great, then repeal it. If you don't care, then vote for full repeal. What difference does it make to you? You already have stricter gun control laws in New York City. They are already not working. We already have been watching the news roll out the last several months that what you are doing down there doesn't work, so please don't impose even part of it on us. Not sure the folks from Nassau, Queens, Suffolk, Bronx, Brooklyn. So then what do I have to do? I have to say, well, I was raised in North Jersey. Oh, suddenly they go, oh, she gets us. Okay, let me think about that for a minute. So apparently we are not all New Yorkers, but if you're from North Jersey, that's an acceptable second. I have to think about that. You know, they say when you're raised in Jersey and you're growing up as a kid, you can take the girl out of Jersey, but not the Jersey out of the girl. This is like this cliche thing that you hear. Apparently, it's a card that you can actually play with the New York State Legislature. Who knew? Apparently, I've got the right shoes, and I'm from North Jersey, so we had the conversations. The next 24 to 48 hours of legislative time is where this whole thing is going to come out. We do not yet know whether they will formally convene tomorrow, Saturday or Sunday. It's possible they simply hold over. The current default thinking is that everybody's going to go home for the weekend, do their photo ops, kiss their kids, and come back on Monday. The governor is threatening to hold them in special session nonstop until he gets his rent control, because that is really a good chunk of his left base. So roughly 2.3 million apartments in New York City are currently up against roughly 6 million gun owners. Now, to me, that's a 3-to-1 ratio. I like that kind of math, right? That's the kind of math. Like, even the governor should be able to understand 3-to-1. It's pretty simple, right? He might not know too much about the Constitution, but I think on the digits, he can get that much about it in terms of our voting potential. Certainly, the Republican conference gets it because, again, the question that's coming up is the primary question. Are you going to primary me for my seat? What we're going to need you to do is this. If you're on Facebook, look at the Scope Facebook page. As we're posting, please call the following. Those are either the votes we need to shift or the people we really need to annoy. And I mean quite flat out, that is part of what we've got to do is annoy. Particularly Senate Temporary Majority Leader Flanagan, who is from downstate, who is not in favor of full repeal, but who is going to be shaping the entire final leg of negotiations. So there are 3 pieces that are left: the details of the rent control bill, a special tax credit that hasn't yet made it into any bill, and us. And the hope is that we can kind of draft in behind, just like 2 cyclists on the road, we can draft in behind the New York City rent control. It's a long shot. I mean, I want to be completely clear, but give you the most up-to-date information that I can. I'm a long-range shooter. I do 308. Anybody who does long-range, you're waiting for that shot. You might have 2, 3, 4, 5 minutes on setup, and if there is no shot, you don't even take up the first stage of your trigger. There is a line of sight through this. What are the odds? Slim. But what odds have we had for 2.5 years? 0. 0. There has not been a minute in 2.5 years that either the Assembly or the Senate have voted on full repeal. So from a woman's perspective, here's what I get when I talk to all these legislators, especially in person the last 2 days. Pillow talk. Everybody wants to talk nice to me. Oh, Paloma, we would. Oh, Paloma, you know I would. Oh, Paloma, you know I stand for... Yeah, gentlemen? It's primarily gentlemen in the Senate. Gentlemen, show me. Show me. I don't get, words are meaningless to me 2.5 years into this with our membership fighting as hard as they do for everything from lawn signs, chicken barbecues, to raffles, to calls, to letters, to emails, to trips to Albany for lobbying day. Words mean nothing to me at this point. What does that then mean for me? I'm then like the woman out. So part of what went on in the dynamic this morning, and you're just going to love this, is one senator and one assemblyman are then crying and complaining to Steve Allstadt, president of Scope. Paloma's making this difficult. Oh, you got to love this. You got to love this. So apparently I'm doing my job The proper title is Director of Legal Services. I'm also an attorney in private practice. And part of what folks, I think, are coming to find out in the legislature is that in the last year in particular, we have found the judicial branch. Gee whiz, you guys won't do anything? Okay, guess what? We can sue without you. So currently there are 8 different lawsuits pending, of which I have 7. And on the 8th one, we represent amici, which are friends of the court. So let me just give you a quick rundown on everything going on in the judicial branch, which may then end up having some success that we seem not to be having in the legislative branch. Start with our recent victory in Robinson versus Cuomo. Yay. First lawsuit in 2.5 years to actually do something against the governor. Bill Robinson, if you don't know him, you should listen to his radio show. It's completely outrageous. It's on 3 times a week on WYSL 1040 AM. It's also podcast, so just if you Google Bill Robinson Second Amendment radio show, it'll come up. It's like therapy. I mean, it's just lovely. You listen to him for an hour and you're good. All the world's good. Bill's got it nailed. January of 2014, Bill said to me, I want to sue somebody. Yeah, like, I'm a lawyer. Yeah, okay, let's do that. Who do you want to sue? The governor. Okay, who else do you want? New York State Police. So we came up with a Freedom of Information request that we thought was fairly simple. The Assault Weapons Registry statistics. Okay, it's numbers, aggregate numbers. That's all we're looking for. Connecticut, which also had a registration deadline, released its numbers within a day or 2 of the registration deadline. The Hartford Courant covered it. It was like the only newspaper to cover it, and it was done. It was finished. It was like a non-issue. Okay, so this many people registered. There was a registration program in California in the 1970s. Canada had one that it abandoned. Australia had one it abandoned. So, hey, we can kind of cross-compare these numbers. This is academically interesting. New York, of course. This is the governor who says, I'm so transparent. I'm going to put in ethics commissions and then disband them. And yeah, you all already know that. You are a highly educated political audience. But he wouldn't give us the numbers. And recently, Judge McNamara of the Albany County Supreme Court, that is our state's lowest court, our trial court level, issued a 7-page decision, 6 pages of which shredded the state's attorney's arguments. It's a beautiful thing. If you haven't read it and you're feeling at all frustrated or like your energy is low on fighting for repeal of the SAFE Act, just read his decision. It's 6 pages of nothing the state said held up in court. Nothing. And then there's just this one sentence, ordered, and just to paraphrase, it says, give Bill everything he asked for. It's a beautiful thing. As a lawyer, I'm going to frame this decision, all 7 pages, just straight across my wall, because what judge has ever been so clear? But of course, this is the state of New York. So, Judge McNamara's decision comes out. It means the state's supposed to give us the numbers immediately. They call me for an extension. You gotta love this. On the other end of the phone is this poor associate attorney. It's not even like the lead attorney. It's not like Schneiderman calls me himself to say, oh, counsel, let's have a peer-to-peer conversation. Can we have an no. It sends in this associate attorney to call me to ask for an extension. Long story short, there are 3 lawsuits, Robinson versus Cuomo, Gun Owners of America versus Cuomo, and Scope versus Cuomo. So all 3 lawsuits I have, we ended up with a combined return date of June 22nd. That's Monday. That gave them a month to figure out what they were doing with 2 of the 3 lawsuits. The 3rd one, Gun Owners of America and I have decisions to make, and so that will happen on Monday. But no numbers, no hint of a number. So to skip ahead to what are we going to do, there are basically 3 things that might happen as of Monday midnight. Number 1, they release the numbers. If I'm working for the governor, I would have gotten out ahead of this thing the day McNamara issued his decision and had a press conference and released the numbers and respected the court and thank you, and here we are and we're done. I suspect it may lead to a little celebrating by Second Amendment supporters, but that'll blow over in the next news story, and mainstream media doesn't cover us much anyway, so just give it up and get it out, maybe on a Friday at 4 o'clock in the afternoon. Instead, now, like every media outlet in the state of New York is so plugged into Monday that it's actually going to get coverage. So maybe they release the numbers. Another option is they file a notice of appeal. Now, mind you, Judge McNamara was clear they had no merit. So what will happen if they file their notice of appeal on Monday is we will file a motion to lift the automatic stay that would kick in by filing the notice of appeal. And we have two of the three possible legal arguments that could be made. Number one, there is no merit to the appeal. Therefore, they should have no protection on the appeal. Number two, it's only being taken for delay. I think it's pretty clear. That's exactly the governor's strategy in just about everything he does relative to our rights. And Judge McNamara was clear in his decision that the fact that we allowed the New York State Police to have a period of 10 months during which we made numerous efforts, both at written and spoken communication, to get through the FOIL request to get results short of suing was more than enough. What's the third option? You know, it's kind of like, what are the odds of this? Extremely slim, but if it happens, it's very dramatic. So the third option is they do nothing. And midnight comes and goes, and Tuesday morning comes, and I still have nothing. On Wednesday, we would then file a motion in contempt against the superintendent of the New York State Police. Just for your legal education, a motion in contempt, if we prevail, could carry a monetary fine and up to 6 months in jail. If you are the governor's PR department, that is really not the option you want to exercise. You don't even want to let us file that motion, because that's just way too good for us in, I think, a lot of ways. So that's the power play, and that's the power struggle as it stands. What will the numbers stand for once we finally get the numbers? Your guess is as good as mine. If the numbers are extremely low, then I think we get to declare total failure of the program. If the numbers are extremely high, then I think we get to declare fraud. Because if they were extremely high, why would you not have released them to begin with? I mean, there simply is no logical explanation at this point for high numbers. There's always this other possibility, and you know, it is New York, that for those of you who took to doing it by paper, they never input it. And for those who did it online, it failed. The Scope Monroe County chapter, which is the subject of Scope versus Cuomo on the foils, we submitted 36 foils originally, of which 36 were Scope members and 3 were visitors who were not Scope members, so it went in as a 33 foil lawsuit. We asked a lot of questions about the New York State Police Field Guide issued in September 2013, including things like their security protocols for this kind of database information, to which the New York State Police replied after we started the lawsuit, "We have none." You want our personal information about firearms in our home, and you're not even going to protect it? Do you even have a lock and key for a filing cabinet for the ones that went in on paper? Not to be silly about this, but I also do compliance work for manufacturers of firearms and ammunition, and am conversant in all the federal laws and regulations that govern their operations. There ain't no manufacturer of firearms and ammunition in the United States of America that could get away with this. Their federal firearms license would be pulled, they would be shut down, they would be fined, and potentially the executives would be jailed. You can't even ship interstate with no security protocols. There are statutes and regulations at the federal level that even govern that. In addition, that field guide had provisions on the destruction of firearms brought into inventory, to which they said, oh, we have no metric. We don't really have any definition of what a nuisance firearm is. Really? So what, it's left up to the individual officer? It's just completely vague and ambiguous? Don't know. So we did a month ago, while all of these lawsuits are pending, issue a letter to the New York State Police signed by Steve Allstadt that gave them 30 days to revise the field guide concerning the destruction of firearms to come into compliance with the recently issued United States Supreme Court case of Henderson v. U.S. If you don't know that decision, it's another beautiful, short, there wasn't a word the government said that the 9 justices agreed with. So we maybe have to kind of be a little nicer about some of the Democrats on the U.S. Supreme Court because they got this one right. I know, it's hard. It's like one of those things where you're like, I can't even say this. But in their decision, They were absolute that your firearms, if owned lawfully at the time of arrest, remain your property, regardless whether you ultimately even would become a convicted felon. Transfer or possession of a firearm as a total permanent disqualification. It's still your property. You get to transfer it to the eligible third party of your choice, or you get to route it to a licensed FFL to sell it and receive the proceeds of the sale of those firearms. So short of the firearm being illegal, for example, you're an interstate gun trafficker, at the point that the New York State Police seize the firearms, they can't destroy them. Not a single one of them. The quote from the New York State Police to the reporter who called him after we did our press release on this issue was simply this: "We know we have a problem." You know what's so great about a little quote like that? If we do sue them, like 2 weeks from now in federal court, that's all we need. That one sentence. We know we have a problem. We've got the field guide. We've got the Monroe County Scope FOILs asking for their policies and procedures on determination of nuisance firearms that they will be destroying, to which they say we have no records. We have no metric. We have no process for this. And now we have this newspaper reporter who has gotten them to say, we know we have a problem. Every once in a while, I love that my job is the same thing as my shooting sport. It's just this nice, clean line of fire that goes out like, oh, I don't know, 1,000 yards. Like maybe I should start shooting F-class or something, you know? We're coming to a place in the judiciary that is thrilling. It has taken a while to set things up, to have enough lawsuits, to have enough papers circulated by the state's attorneys, to have enough interviews running around in the press, for us to start triangulating, essentially, the state on all of its lies, fibs, and exaggerations. But it's actually all starting to come together. The big federal cases, let's touch on those for a minute. NYSRPA, I know some people say NYSERPA, and I'm always kind of backhanded to the NYSRPA. It's the New York State Rifle and Pistol Association versus Cuomo and Montgomery versus Cuomo. So let's start with NYSERPA. That case started in March of 2013. It's got a whole bunch of complaints in it, but the primary argument is that the assault weapons definition is unconstitutional in violation of Heller and McDonald, which say firearms in common use are essentially a fundamental right. So part of what this gets at then is the question of what is a firearm in common use? What's interesting about the New York case and two companion cases that are tracking with it, the case out of Connecticut, because Connecticut had a statute that passed similar to ours a couple months later, and Maryland, which was the third state and the third case, is that essentially all three states' attorneys' offices have conceded firearms are currently in mass production. Basically, all platforms are in common use. You take an AR lower, it's in common use. You got how many produced on an annual basis? Well, the ATF actually collects data about firearms production. It's actually got a 1-year lag on it due to the Trade Secrets Act. So your data is, a year old, arguably. But we passed the 100 millionth firearm in civilian use production figure 2 summers ago. Yeah, you know all the name brands. I don't need to say it so we can all just kind of wave the American flag and be thrilled, other than Colt filing for bankruptcy. We'll skip that for tonight. What they're now in are the weeds. Partly this question of, does New York's definition of the assault weapon become an effective ban? The state is arguing, oh no, but there are so many variations that even if we're down to a one-feature test, you still have, dozens and dozens and dozens of firearms to choose from. Look, we have brochures with photographs in them. Have you all seen those brochures? The funny thing about those brochures, that was another one of our foils out of the Monroe County chapter. We asked for all the drafts. They don't want to give us those. Our understanding is that they actually made mistakes in several of the, you have to love this, in several of the books, and had to keep revising them. As people pointed out, certain of the firearms they had listed did not have detachable magazines, like certain models of the SKS, but they don't want to admit any mistakes being made. We'll see. The Second Circuit Court of Appeals heard oral arguments in the NYSRPA case on December 9th. It is fully submitted. The Connecticut case was heard in tandem, same day, same time, different attorneys from the two states, same team for the plaintiffs. Maryland's case was argued March 25th by oral argument. So potentially we have two circuit courts that will rule: the Second Circuit Court of Appeals, which is ours, and the Fourth Circuit Court of Appeals, which actually is based in Maryland as well. The next step is going to be an application to the United States Supreme Court, no matter which side rules. Simply out of the three states, no matter which side wins, there will be the other side who lost asking for the U.S. Supreme Court to grant cert. We're back now to small odds. The U.S. Supreme Court gets about 10,000 petitions every year for cert, and they grant about 75 to 80. I, however, from beginning have said we're going up. Simply for this reason: Justice Scalia is not getting any younger. He wrote the majority opinion in Heller, and in that Heller decision, which goes on ad nauseum. I don't know if any of you have read Justice Scalia's works, but he'll do things like spend 20 pages on a comma in a statute. And you kind of have to weed your way through to, like, okay, where's the ruling? Just say the word fundamental, Judge. That's all I want you to say. I don't care about all the others. They're fundamental. He's got a sentence in the Heller decision that he's leaving to a future opinion which firearms are going to be protected. Most people missed that in their analysis of Heller, because Heller, in combination with McDonald 2 years later, was such a joyous event. So at that time, I was the one that everybody was like, oh no, she's Chicken Little. I'm running around going, the sky is falling. Great, it's fundamental. What other ruling could they have reached? Of course, the Second Amendment contains fundamental rights. This is the sentence that's the IED. Right here. Right here. Justice Scalia is suggesting there's analysis to be had as to whether we're keeping muskets or long range. What's more bizarre, if you listen to the oral arguments in Heller, McDonald, the Second Circuit, and the Fourth Circuit, kind of put them all together, judges are fascinated with full auto. Now, none of them have apparently ever fired full auto listening to their questions. They don't even know what states they can do it in. They don't even seem to realize that full auto is a National Firearms Act firearm that is not banned at the federal level at all. It's got to be registered. If you go to the ATF website, you can look up and see there's about 328,000 of them. You can even see the breakdown by state. The ATF knows where they are. And apart from kind of the rumors that float around the internet about one supposedly being used in a bank robbery, and I've never been able to track that down completely to verify it, I've got no reported crimes with full auto since NFA went in. But the judges are fascinated with it. And so one of the arguments the state of New York made in the NYSRPA versus Cuomo lawsuit is that if you shoot semi-automatic enough rounds, it spontaneously combusts into full auto. No fooling. No fooling. You laugh. I'm so glad to have an audience with even basic technical firearms acumen. Really, seriously. I couldn't make this up. I wouldn't have any credibility with you if I did, right? Yeah. So what do I do when I get this affidavit as part of the NYSERPA record coming out of the attorney's office for the New York State Police? That's who signed off on this affidavit. I go shopping with my affidavit everywhere. Is this true? Has anybody ever seen such a thing? Am I the one who's wrong? I mean, this is a sworn affidavit in a federal lawsuit of great magnitude to the history of the Second Amendment. Finally, I find someone at the Rochester Police Department who says, oh yeah, once we had one, but when it happens, if it does, it's a burst, it's not full, it's a probable jam, and really, if it happens, you gotta just cut the thing up because it's gonna hurt you at some point. That's how out of control the pro-gun logic is in their arguments. No fooling. State's attorney's office on any of these lawsuits has no idea about just basic firearms anything. One of the big action items I keep shopping to the SCOPE chapters and to other groups that have me speak is, would you please take a lawyer to the range? Please. If your lawyer says they hunt, get the cobwebs out of the damn shotgun and walk out the door with you. If they say they're afraid, bring them down and just show them a demonstration. In fact, find the most liberal lawyer you know. Auburn, Weedsport, anywhere. Take them to lunch, if you have to, and take them to the range. Just show them one firearm, demonstrate how it works, let them know if you've been shooting since you were a kid, and your father and your grandfather took you out. And in fact, the first firearm you had came from your uncle who served in World War II, and now you're having to saw off the bayonet lug in order to be able to keep this piece of history and this family heirloom. It is our responsibility to communicate to the judicial branch what it means to be a firearms owner. What they have seen for the last 40 plus years, in particular, are career criminals who are the living proof that gun control statutes don't work. If you sign yourself up for the ATF's press releases, each of the different divisions throughout the United States love to tout when they arrest somebody. Here's the bad guy, we arrested them. And then you look at the rap sheet on these predominantly men. They've blown through every major federal gun control piece of legislation since the 1960s. I don't know what better argument I can make. But if we don't meet the judges and we don't meet the lawyers and we don't explain to them what it means to us, the only explanation they're getting are from criminals. That's it. So part of what SCOPE is doing in the NYSERPA lawsuit is this. We're doing an amicus brief to support the motion that the U.S. Supreme Court will accept the case from the Second Circuit if we lose, or that it wouldn't if we win. We have built a coalition of more than 125 groups from all over the state of New York to come together in what I believe will be the single biggest coalition amicus brief in the history of the United States Supreme Court. Everything from SCOPE chapters to conservation groups, to retired law enforcement groups, to a variety of political parties have all signed on. Why? Because we are the vast majority of gun owners, not criminals. And we need to introduce ourselves to the court. The NYSERPA record is deep. It's 9 volumes. It's about 2,500 pages. It covers all the legal arguments you would want to make. So what we're going in on is the very personal touch. It's the judge. Let me introduce myself. My name is, and I'm a woman shooter. I'm the fastest growing segment of the shooting sports for the last 3 years running. And as far as I'm concerned, Moms Demand Action are falsely co-opting that what? A mom shouldn't have a firearm? We shouldn't be able to protect our kids in our own home? No, we should send them to gun-free school zones instead? I'm not going to get that sassy in the brief, I promise. I promise. I'm just a little wound up from Albany. I promise I won't get that sassy in the brief. But you get my point that we need to put in the human conversation. So for any of you who are also members of other clubs and associations, whether it's rod and gun clubs, police benevolent associations, unions. God, I love my Central New York unions who close for like first day of hunting season. Yeah. I was down in Albany today. I've got on my SCOPE pin and I've got on Carpenter's Local 271, and with me I've got somebody from that local, right? huge shooting sports tradition. That's what we need to bring to court. It's not just this big black scary thing that U.S. Senator Dianne Feinstein has maligned since the minute she arrived on the Senate floor in Washington, D.C. Other federal case. Take a deep breath, because this is where I always lose people. I see everybody just sink in their seats as I go. So Montgomery versus Cuomo. That's the whole mental health piece. Part of the SAFE Act, sleeper provision, nobody but somebody like me looks at. I've got about 8 years in on federal HIPAA compliance. Like, who knew? There was a Second Amendment attorney that also did HIPAA. I'm the governor's worst nightmare on his mental hygiene program. The state's official position in Montgomery versus Cuomo is what they did is innovative. Keep that word in mind while I walk you through this. Here's how the system works. It's called ISARS. It's the Integrated SAFE Act Reporting System. Your medical provider fills out a form that includes a mental health diagnosis from the DSM-4R and up to 500 characters worth of freehand narrative, and hits enter, and off it goes. Nothing goes into your medical chart. You are not notified. That form goes through the county to the State Office of Mental Health. It goes across to the Division of Criminal Justice Services, across to the New York State Police, down to the county level and out to your licensing officer, and potentially out to local law enforcement. Because once a 9.46 report is entered, the New York State Police treat that as mandatory revocation of your permit and confiscation of all firearms, including long guns. Do I need to let everybody breathe? You all just like froze in your place.
Does every doctor need to see?
No, no. Let me take you just one step down into the weeds, because that's always a question I get. So who is it that's actually reporting? Let's grab a statistic and then let's go to who. The current estimate is about 75,000 people in the ISARS system. The reporting rate is roughly 750 people a week. According to the state's papers in Montgomery, it's roughly 20% of operating capacity just for state-affiliated hospitals alone. The state is looking for a reporting rate as its goal of about 3,500 people a week. Currently, the information is about 80 to 85% of those reports are coming out of state-affiliated hospital emergency departments. We do not have any kind of a breakdown in the Montgomery case that would be part of discovery, several steps along if we survive the current motion. We know some of the counties are reporting at higher rates than others, and we know some of the counties are actually snagging permits and firearms at higher rates than others. Even considering the population of New York City, it's Monroe County with the highest rate at 38 people as of last October who have been reported, suspended or revoked, and confiscated. Part of the interesting public safety argument about all of this is as follows. You don't get snagged the same day. So let's think about this for just a second. You are allegedly having a mental breakdown that would make you a person unsafe to own or possess a firearm. Some of my clients get a letter by first-class mail up to 2 weeks later saying, will you please turn in your firearms and your license? Last time I checked, that's a pretty long window on somebody who's dangerous. Don Montgomery, who is the lead plaintiff, got a telephone call several days after his hospital visit. Now, he's Suffolk County Police Department, retired after 30 years and a veteran. So they gave him a courtesy call from the Suffolk County Sheriff's Department to say, Donnie, we're coming for your guns. Can you have them ready? My client, of course, is saying there has to be a mistake, so no problem. Let's follow what you've got to do. And that's then, of course, where his odyssey begins. A couple of the people, one of whom I represent, one of whom is represented by a different attorney in a different lawsuit, were put in the back of police cars for a period of approximately 2 hours, one of whom was simply driven all around upstate until they finally took him to a hospital 30 minutes from where they picked him up at his home. The other needed insulin. and they left him in the back of the car for an hour and 50 minutes by law enforcement's own logs that have already been produced in the lawsuit. And the very first thing they did at the emergency department was jam him full of insulin. And the very next thing that happens with him medically is he's clear. Of the plaintiffs in any of these lawsuits were assessed to be dangerous. None of them. One of my clients in the Montgomery case was only at the emergency department for 2 hours. They didn't even admit him. Suspected stroke, sleep deprivation, hallucination. And that's how it went through the system. Let me make it one step worse. We knew ISARS had to be operating. We knew plus or minus how it was operating. We needed a plaintiff. Don came. He got started. Other people then came forward. There's another number to know. What I just described is the 9.46 that was part of the SAFE Act. But we also knew there was something else that had to be operating because we were getting strange outcomes. When you purchase a firearm from an FFL, you fill in ATF form 4473. We've all done it how many times? Can't do cross-offs, you have to initial, don't do it in pencil, do it in pen. I mean, you know the drill. You buy it more than once, you're still filling it out. We had people submitting those who were failing in a way that wasn't making any sense. And then we're finding out from the state of New York that the state of New York is using 9.41 of the mental hygiene law as an admitted misnomer. Well, the problem with section 9.41 is that's an involuntary commitment to a mental institution. 9.41 reports get uploaded to the FBI. The FBI, through the ATF, administer the NICS index, which is what your Form 4473 runs against at the federal level. So essentially what New York has admitted already in this early stage of Montgomery, where you never thought you would see such a thing, is that it's freely uploading under 9.41. To what extent, we're not sure, partly because most firearms owners don't buy a new firearm every 6 months, and partly because when you fail and you get a deny at your FFL, they don't tell you the reason. They're not permitted to tell you. They give you a ticket with a number. If any of you have had a failure, you don't have to raise your hand. This is kind of how it works. The good FFL is supposed to give you a number. You then get in touch with the ATF. They open an appeal review. You can do it online. It's very simple. You can have an attorney, sign the attorney form, submit it, it goes in. Even then, they're only confirming or denying. If they again deny you at the ATF administrative level, you then have to kick yourself up over into district court, and then you're really starting to, I mean, you're hiring an attorney for a federal lawsuit. So you've got all this kind of complication running around in it. The conversation currently with the ATF and the FBI is whether there is going to be a way to demand that they do an audit of every upload under involuntary commitment by the state of New York since 2010. Let me key you into that date. 2013 is a SAFE Act. ISARS goes live, just as a point of reference, in April of 2013. What I knew was going on in the background turns out apparently to be the case. The federal government had passed a NICS Improvement Act through which Congress appropriated tens of millions of dollars to states which wanted to apply to get money under two provisions in particular: the misdemeanor crime of domestic violence and the involuntary commitment to a mental institution. So, what is it that New York does and freely admits in its lawsuit and is part of the public record already for the state of New York? They decided, free money. We'll take free money. We'd love to report more people for a permanent federal disqualification. We'll take it. So New York, since 2010, has gotten the most money of any state. Not all states participate, less than half do. But they've gotten the most money of any state in the United States to be ramping into a database build for 3 years even preceding the SAFE Act. So for everybody who's all upset at legislators because of this budget process and we didn't defund the SAFE Act, that's not where the primary funding has been coming from. It's been federal driven since 2010. I can make it one step more fun in case you're already like ready to run out the door. Let me put the nail in the coffin on this one. So the state's essential position in multiple places is this. Well, if you're wrongfully reported, go to the Office of Mental Health. You gotta love that. The Office of Mental Health online has its relief from disability program. You can download this little one-page PDF form that looks so polite. How could it possibly be a problem? Well, here's the deal. Somebody reports you with the click of a button with no documentation at all to back up what they've just put in a computer, and with absolutely no verification at all, as it's skidded straight across all of these agencies for the state of New York, down and out at your county and local level. But what the instructions say is you have to be ready to give up 20 years of your medical records in certified form in order to submit that one-page form. And then there's this little bit at the bottom that you have to be willing to subject yourself to a mental health examination by the mental health professional of the state's choosing. It gets one step better. You gotta love me. I'm trying to like wind you through this path of like public awareness while at the same time not letting you slide under the table. The federal government did an audit of participating states in this NICS improvement program. About a dozen states turned in statistics on their state relief from disabilities program. New York is at the top of the chart. Can you imagine such a thing? We're at the top of something. Yeah, it's because we have a big zero. Out of the approximate 25 people who tried to submit for a relief from disability, they reversed 0 of those who requested reversal. 0. No other state had 0. Even with smaller numbers of people applying, no other state had 0. So it means you're reported, it's not in your medical chart. You can get your medical records, it won't be there. You ask the state through a Freedom of Information request, have you got me in your database? They say we can't tell you because it would violate HIPAA. I can't make this up. I just can't. You know, me and Ellen DeGeneres are like going to start a show together. It's going to be left-right leaning, and I'm just going to fall over to the right. You literally have to sue in federal court to find out if you're in this database. So what did we recently do? I hope this chapter participated. Did you do your foils recently? Yeah, okay. You got your letter today. I was at, last night, the Ulster County brand new committee. So I'm in Albany all day, drive down to Ulster County, then back to Albany this morning. We had members from several different counties. And last night, they had somebody who told me that the New York State Police letter arrived, said we had submitted 606 foils. Is that the same number in your letter?
Yeah, 606.
You gotta love that. And that the return date is June. Oh, my heart goes out to them.
June 16th.
of next year. They want a year to get back to us on whether we're in the database. We held the press conference on June 9th in the morning. We had that huge stack of foils. The room was packed at the Legislative Office building to overflowing. Before you walk out, I have to say 3% was there, Oath Keepers were there, Scope was there, Minutemen were there, Common Core parents were there. Packed to overflowing, including our first TV station, which ran us at 5:36 and 11 in Albany. I'm thinking about the governor having hot cocoa at 11 watching that. It's great, right? We took this stack by hand, myself, Steve Allstat, Jody Jackson from the Adirondacks, Kevin Sisson from Schoharie County, and Lois Reed also from the Adirondacks. Took it by hand over to New York State Police. The poor officer at the reception desk is calling the records access room going, what do I do with this? I've never seen anything like this before. We're making history. The only consolation prize I can bring you, aside from the Robinson victory, which now we're going to defend like hell, and the other pending lawsuits seeking to bring down various of the provisions, and the fact that we have 2 more that we're working up to file in federal court as well, is that we're making history. I mean, at this point, we have so many grassroots initiatives, whether it's in the judicial branch, whether it's pushing our legislators to represent us, whether it's handing the New York State Police hundreds of foils in a single day, and they're still pouring into the Scope office. They've been packaging them up every Friday since. We've grown so much in sophistication in the last 2.5 years. I don't think we were ready for the SAFE Act to hit. Scope's been around 50 years. But God Almighty, weren't we all shocked into standing up and fighting and speaking out and doing everything that we could? Scope is now in more counties than ever. The chapters are more active than ever. We've now built a huge coalition. And so when I was in Albany the last 2 days, I kept saying to senators and assemblymen, you do understand I'm standing here representing 6 million people. I had on higher shoes, and I looked a little bit more imposing saying it. And I was joking just a little bit with one of our local upstate senators, and I said, well, who I'm really here on behalf of is everybody to the right end of New York State Rifle and Pistol. Yeah, you should have seen his eyebrows go up on that. My license plate on my truck say, don't tread. Who the hell do you think I'm representing? I might be a woman, but I mean, please, can we just be clear about something here? We have to redouble our efforts. As I said when I started, the next 24, 48 hours of legislative session, whatever those hours turn out to be, basically I have court in Syracuse in the morning on a totally unrelated matter, and then I'm essentially back up the thruway to Albany, glad that I threw 5 days worth of clothes in my suitcase when I thought it might be 1 day, thinking, yeah, I know how this is gonna go. I've got somebody on hold, because I live in Webster, to drive me more clothes, if that's not enough, and we're just gonna camp out. So for the first time in Scope's history, as a 501c4 dedicated to political education, we are everywhere. There is nowhere the governor of this state can go that he's not seeing SAFE Act signs. I drive everywhere in this state, to all of our chapters, everywhere west of the Hudson. And Steve Allstadt is down starting a Nassau County committee this weekend. You know whose county that is, yeah, right? We're everywhere. And that's the message that Albany needs to get, is if you thought you could pull one over on us once, that was really all we needed. You're not doing it again. We've held the line on any additional legislation so far. The ammunition background check system never went live. The generally accepted theory is that it is ready and the governor's too afraid to start it. I can neither confirm nor deny the accuracy of that. It simply seems to be the generally prevailing theory on the ground in Albany. The handgun license recertification process, equally not up and running. Originally, there were supposed to be 7 pilot counties, then it was 5, then it was 3, then it was just down to Albany County was going to be the pilot county. Nothing has been launched. And in our FOIL requests, they said there is nothing. Because we asked, of course, for all the papers, all the records on this recertification process. The one presentation that was made in Wayne County, they wouldn't give a copy. They presented it and ran back to Albany with it. So thankfully, in Wayne County, they made some notes, sent them off and said, can you confirm this is what you said? And actually, a letter came back clarifying some of it and then skipping a whole bunch of it. So our guess is as good as anybody's whether it's actually going to happen. Lights out. Yeah. So that's the essential message. Let's do kind of our takeaways. If you're on Facebook, watch for the action alerts for the next few days. Steve will also have e-blasts sent out, so at the least open your emails. We're trying to make sure the telephone number is right next to the name so you can make the phone calls. It's working. Please keep it up. Please redouble your efforts. Number 2, take a lawyer or judge out to the range. And number 3, every single person, I know I saw them when I came in somewhere, grab a Scope membership form. Everybody knows somebody to whom you can give a Scope membership if they won't buy one. One of our chapters gave a membership to the governor.
Did he accept it?
He is a member of SCOPE. We issued it, we sent it, he gets firing lines just like you do. You never know, right? Be creative, be an activist, get everyone you know to join you. If we lose the 3 cases at the U.S. Supreme Court and we lose the White House in 2016, there won't be a state we can move to. Those of you who are leaving, going down to North Carolina, and so there won't be a state you can move to. We have to hold the line in New York. We've got to win in some of these lawsuits, and we have to push like hell to get the legislators to do a full repeal right now. So that's my essential message. Hopefully that wasn't like so much that you're going home completely depressed. There is, I'm sure, lots of ice cream in the food court to make you happy again after you leave me. But we'll see if we've got some questions. I guess the lights go out. So however people want to do things. Yep.
Will you have a gist of the information that you gave at this meeting? My memory's too short.
Well, my understanding is it's actually being recorded. I know last night's meeting was recorded, and so I know there are a few videos sort of starting to pop up. I do have also a website for my law office as well. My SCOPE card is here. So, you know, we're kind of scrambling as much as we can to put out things. The other thing that's going on with SCOPE, which is very exciting, is we have a number of new committees and new chapters. We actually have a whole new round of chairs as well, who are doing things like developing PowerPoints that can be easily shared, developing short videos that can be shared. So it's a growth process, and we're working on it. At the moment, we're trying to hold the fort in Albany, but, you know, all suggestions route to Steve and to his secretary, Susan, and that's a big part of what we'll be discussing in July and August when a lot of the chapters are on recess, is what's the agenda for next year. Yep.
Do you have any information on what's been going on with Cuomo and New York State being in the hot seat of what happened in the Northwest break that shouldn't have happened?
I'm sorry, I can't quite hear.
Do you have any information about what's going on with Cuomo and New York State and what happened in this prison break up north? What shouldn't have happened?
Oh, well, I do. Yeah. No, it's very exciting. So the question is, do I have any information on this whole Dana Mora thing? I do. It was his best photo op ever. He looked great, right? So I'm thinking that, you know, ladies in the room, help me out here, because I hand stitch stuff, I sew. I'm thinking we just go and measure the curtains now. Pink American flag, a little SCOPE emblem, maybe a little 3% on the other one. You know, we can give them the full range of what we have to offer.
I understand that your lawsuits have nothing to do with what's going to happen with the whistleblowers.
With who?
I understand when I hear that your lawsuits aren't going to even compare to what's going to happen at this one.
Well, y'all know who my legal hero is at the moment. I mean, come on, everybody knows it's Preet Bharara. Holy cow, right? Gee whiz. If you haven't read them already, go online and grab the complaints filed against Silver and against Skelos, both of whom I saw and talked to yesterday and today, by the way. They still have their seats, but they don't have a gaggle of people around them anymore like they used to. And when SCOPE was there for lobby day recently, we sat down, several of the chapter chairs and myself sat down with then Majority Leader Skelos. I saw him today, so I say, Dean. And he's trying to scurry away, and it's actually the sergeant at arms at the gate to the Senate where you have to stop. Beautiful Albert Paley Gates, who pulls him back. Poor guy. He really didn't want to talk to me. He recognized, yeah. And he comes back, and I'm thinking, okay, is he not happy that at least one person wants to talk to him out of this whole lounge area where all kinds of people are chasing all the senators to lobby? He was, yeah, no, we said hello and exchanged pleasantries, and I said, I hope I can count on your vote for full repeal. It was nice to sit down with you. He took my card, and yes, I remember you, and that was that. He was gone before I could complete my handshake, so they're still there. They still hold their seats. They refuse to resign. There is a new temporary majority leader in the New York State Senate. As we know, it should have been DeFrancisco. Whatever all happened there, that several of our upstate senators shifted vote to get behind Flanagan as majority leader, but there we are. So that's kind of what I got on that update. Yeah.
With that in mind, what you just said about DeFrancisco and Nozzolio and Seward, now I went with the Cuyahoga County chapter and we sat in with Senator Nozzolio and Senator Seward, both of whom swore to us that they were going to root out all monies for the SAFE Act, that they were going to, before they voted for the budget, before they flip-flopped after Andrew Cuomo's call to then support Flanagan. Does Scope, is their official position, do they have an official position on whether we've had enough of the frauds in Albany that take our money every election cycle the road? Will they be primaried?
Well, the unofficial position is this, and Steve Allstet's heard me give it before, so ladies in the room, y'all join in. If your lips are moving, y'all know that song, right? Your lips are moving, then you're lying, 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 right? I mean, I think if you look at Albany with that in mind, nothing that's going on is in the least bit confusing. They know what we expect of them. That is clear. If there's any one question that I am getting from the senators in face-to-face conversations yesterday, today, it's, will you spare me from a primary if I vote for full repeal? And my response is pretty simple. Again, it's back to that actions speak louder than words. Do the right thing first, and then we have a year and a half to analyze. And we will. Your question is unethical and probably a violation of the ethical rules of the New York State Senate to begin with. There are some, yes, they do exist, they are in print. So don't be asking me that question, is a little bit my first line of response. But the second line of response is, right now, I got 3 years and I got nothing. I do not even have a symbolic vote that didn't clear the Senate. I have nothing. I have 2 numbered bills from Marchione and Nozzolio. They voted on neither. I got a committee the Monday night that the SAFE Act bill came into the Senate. There was 13 Republican members and 12 Democratic members, and you cleared that bill through committee to hit the floor for a vote. And now, yesterday, you want to tell me it was a done deal on the floor, therefore you couldn't jam it in committee? My response was simple. Do you people know nothing about Senator Cruz? And the pushback was, well, that didn't work too well. And my pushback to that was, he's running for president. There is a political style to fire in the belly and spending your capital and shut the damn federal government down if you have to. It's 3 branches. It's separation of powers. It's a system of checks and balances, and my hero, James Madison, wrote it. So get over it. The response from the senator, well, then maybe I should run for governor. Didn't work for me. It just didn't work for me. So there'll be time to sort of debrief later and analyze the whole thing. There is no official position yet on primaries other than there is no position. Do the right thing. And then we have a year and a half to talk about it. Yep.
I don't know if you're aware, but for some odd reason I get invited to all the governor's talks. And I was at one at SU. And he was announcing this program for convicts. And part of this program was being able, through the system that checks on guns, that he was developing for New York State. I happen to have to do a lot of business with the state of New York. Are you aware that they use third-party vendors, including Xerox, to try to do this? I don't think you're going to get your numbers because Xerox isn't in with the state troopers. What are your thoughts about that?
Ultimately, for FOILs, under Freedom of Information requests, it's the agency or office that manages and owns the information. The state already admitted in Robinson versus Cuomo that it has the information housed by the New York State Police that we're asking for. That's why Judge McNamara was able to issue the ruling he was of turn it over. In the Scope versus the Scope versus Cuomo lawsuit, the judge ordered the state to submit an answer to our original petition as to whether the records actually exist. So we have one extra step in the Scope lawsuit, but in the Robinson lawsuit, the state admitted it had every piece of statistical information housed at the New York State Police that we requested, and it's directed to be turned over. So assault weapons registry totals by zip code, by county, by efforts, even if not done, by mail versus online. So we had 16 categories of how the numbers might be cut and logged, and they were directed to turn it all over. They've admitted they have it all.
Yeah, but what about the registration part of that, where he was putting in this elaborate system to do it? Is it in? Is that what you're saying? That
There is an online system, but as I said, whether it's functioning, who knows?
It functions.
So we'll see what the numbers are when and if they release them and go from there.
Unfortunately, we have to shut this down.